Committee, I'll call us back to order. Order. Okay, thank you very much for your attention, committee. Today we are conducting a hearing into our legislative review of Bill 6, Cannabis Legalization and Regulation Implementation Act. Today, the purpose of today's hearing is to discuss the contents of the bill with the Honourable Louis Sebert, Minister of Justice, and staff from various departments across the Government of the Northwest Territories. We will not be hearing from members of the public today. However, May 3rd will be the opportunity in Yellowknife to hear from members of the public on their views on Bill 6. That meeting will begin at 6:30 in the evening in this location, Committee Room A of the Legislative Assembly. This is a fairly extensive piece of legislation, and it has taken two standing committees to come together to work on it. After today, we will be beginning a comprehensive round of consultations throughout the Northwest Territories over the next 2 weeks, and in preparation for ultimately reporting the bill back on the bill in the upcoming legislative sitting in May and June. So without further ado, I will ask committee members to introduce themselves for the record before turning to the Honourable Minister of Justice for opening comments. We'll start here with Mr. Bolio.
Thank you, Mr. Chair. I'm Tom Bolio, MLA for Tuneda Willady.
Good afternoon, Shane Thompson. Good afternoon, Shane Thompson, Nandi.
Good afternoon, Danny McNeely, Satu Region.
Michael Natalie, MLA for Detchell.
Julie Green, Yellowknife Center.
Kevin O'Reilly, Frame Lake.
Good afternoon, RJ Simpson, MLA for Hay River North.
And I am Kieron Testart, member for Cam Lake and chair of the Standing Committee on Government Operations. With me at the table as well are Megan Welsh, research advisor, Michael Ball, committee clerk, and Alyssa Holland, law clerk of the Legislative Assembly. And without further ado, we will move to Minister of Justice for opening comments. Minister, you have the floor.
Thank you, Mr. Chair. I'm pleased to be here to talk to you about Bill 6, the Cannabis Legalization and Regulation Implementation Act. With me today are officials from the Departments of Finance, Justice, Infrastructure, and Health and Social Services to assist in answering your questions. They are Sandy Kolgektar, Deputy Secretary to the Financial Management Board, Kelly Bluck, Director, Fiscal Policy, Emily Ingerfield, Manager of Policy and Planning, Doug Ward, Legislative Draft, Megan Birch, Manager, Legislative Affairs, Gary Toft, Director, Policy, Legislation and Communications, Raven Bedingfield, Senior Policy Advisor, and Judy Kaintz, Director, Prevention Services, WSCC. I am also joined by my Ministerial Special Advisor, Stephen Dunbar. As committee members are aware, the development of Bill 6 has involved significant interdepartmental collaboration and has benefited from feedback from the public, Indigenous governments, municipalities, and other stakeholders received during an extensive engagement process that occurred during the summer and fall of 2017. We recognize that not everyone will agree with all aspects of the legislation being proposed, but it is important that as a government we make the best decisions we can to design a system that puts the health and safety of our residents first and that follows the guiding principles that received overwhelming support during the engagement. In addition to the feedback received from our cannabis engagement process, other important factors that were considered when determining our approach included discussion and information from other jurisdictions, discussion with enforcement partners, practical and financial implications for implementation in the required time frame, and current research on the health impacts of cannabis. Bill 6 consists of 3 schedules. In the first schedule, the Department of Finance proposes the new Cannabis Products Act. This will enable the Government of the Northwest Territories to assume responsibility for the importation and sale of cannabis products through the Liquor Commission under the direction of the Minister of Finance. The Act will provide for a cannabis mail-order system to communities that do not have a retail store, and those communities will have the option of holding a plebiscite to decide if restrictions or prohibitions will be put in place. The new Act will set 19 years of age as the legal minimum for purchase and possession of cannabis and maintain the federal possession limits, which will allow adults 19 years of age and older to possess up to 30 grams in public and to grow up to 4 plants in a household. In the second schedule, the Department of Health and Social Services is proposing the new Cannabis Smoking Control Act. It will place restrictions on the public smoking of cannabis products similar to laws governing the smoking of tobacco products, with a number of additional restrictions. The new act will also require cannabis retail outlets to post health warning signage distributed by the department. In the third and final schedule, the Department of Infrastructure has proposed several amendments to the Motor Vehicles Act to create additional penalties for drug and alcohol impaired drivers. These will include zero-tolerance laws for novice drivers, drivers aged 21 and under, and commercial drivers. Administrative license suspensions will also be established for all drivers who fail a standardized field sobriety test or an evaluation by a drug recognition expert. The current legislation governing impaired driving will be amended to appropriately address drug-impaired driving and to reflect the repeal and replacement of the transportation section of the Criminal Code under Federal Bill C-46. Amendments are also proposed to allow the Registrar of Motor Vehicles to release drivers' abstracts directly to law enforcement. Mr. Chairman, I am sure members will have questions on the policy rationale behind our proposed approach, as well as our implementation plans leading up to and beyond legalization. I am pleased to be joined by officials from the Departments of Justice, Finance, Infrastructure, and Health and Social Service to assist in answering your questions. I would like to acknowledge not only the work and collaboration amongst departments to bring forward this legislation under the challenging timelines, but also the willingness of the committees to work together to review this bill and to ensure we are in a position to respond to the federal legislation with a regime that was designed with specific consideration given to the Northwest Territories context. Finally, Mr. Chairman, I would like to add that the Northwest Territories has not been alone in working through what has been a challenging undertaking. All provinces and territories have faced similar challenges in preparing for what amounts to a fundamental societal shift in how a substance that has a long history of being illegal in our country is viewed. No government can be expected to have all the answers for how the legalization of cannabis will be rolled out, but I am confident that we have come up with a reasonable approach for the Northwest Territories at this time, and like all jurisdictions, we will be learning and evolving as we go. I would be pleased to answer any questions the committee may have regarding Bill 6. Thank you, Mr. Chairman.
Thank you, Mr. Minister. And before we proceed to questions from committee, I just want to recognize that we are joined by Norman Yakalaya, a former member of this Assembly. Thank you for being with us today. And now I'll turn to committee. Committee, I will give you 5 minutes to ask your questions, and then we'll move on to another committee member, but you will have time to be placed back on the list. And we'll start with my co-chair, Mr. Thompson.
Thank you, Mr. Chair. So my first question to the minister, in regards to plebiscites, especially for small communities, how is that going to be implemented going forward? Thank you, Mr. Chair.
Thank you, Mr. Thompson. Minister Sebert.
Thank you. The plebiscite sections are, of course, in the Act, and if I could refer a committee to Part 4, Community Control. And if there is a plebiscite, there's several steps that need to be taken. A municipal council or band council makes a resolution requesting that the Minister of Finance hold a plebiscite on the establishment of a cannabis restriction or prohibition system. Step 2, the minister orders a plebiscite, sets the question, fixes the date, and appoints a returning officer. Step 3, plebiscite is held, and then depending on the result, the minister makes regulations to implement the system. The sections dealing with that are, as I say, in Part 4, Sections 12 to 19. Thank you.
Mr. Johnson?
Thank you, Minister, for that answer. So, in regards to the small communities, should they have a plebiscite, what would hinder them from not being able to do a plebiscite? So they've gone, well, I guess what's the challenges from stopping them from having a plebiscite? Thank you.
Mr. Minister?
Well, they would have to, of course, request a plebiscite, and I suppose that would be determined by the submissions or concerns that are raised by the community, but there is a process for holding a plebiscite should one be requested. Thank you.
Mr. Thompson?
Thank you. So in some of the communities, there's both a band council and a municipal council there. So who can initiate the plebiscite? Thank you.
Mr. Minister?
Thank you. If I may refer to Section 13, a municipal council or band council may by resolution request the minister to hold a plebiscite, so it could be either.
Mr. Thompson?
Okay, thank you. So if they do a plebiscite and they allow, and a cannabis store has been brought into the community, and, you know, a couple of years later, the community realizes that this is not what they want, can the community then actually host another plebiscite to remove the sale of the cannabis or the removal of the store? Thank you.
Mr. Minister?
The ability to do so is constrained by Section 14, if I might read it. If a cannabis store operates in the community, no question may be asked in a plebiscite initiated under Section 13 that would, if supported by the voters, authorize the making of a regulation that would have the effect of prohibiting or restricting the sale of cannabis at the cannabis store. So once there's a cannabis store established, that does limit what the community can do. Thank you.
Mr. Thompson?
So it eliminates the community. Is this similar to how we do the liquor? Is it similar to that? Thank you.
Mr. Minister?
Yes, so I understand.
Mr. Johnson?
Okay, thank you. So I guess my next question is that the government of Northwest Territories has identified the liquor stores to be the avenue to sell the product right now. So I guess my first question is, does the liquor store have to sell this, or is this something that they have to request? Thank you, Mr. Chair.
Mr. Minister?
Thank you. Certainly they do not have to. We are attempting to enter into agreements with liquor stores, but if they don't wish to sell cannabis, they certainly don't have to.
Mr. Thompson?
Okay, and so in regards to plebiscites, then if we have the 6 communities that have liquor stores, and how are we going to be able to get the plebiscite? Because I know in some of my communities, i.e. Fort Simpson, they want to maybe look at having a plebiscite, but we do have a liquor store in there. So what is the time frame being allotted to them to be able to get this plebiscite done? Thank you, Mr. Chair.
Mr. Minister?
Well, they certainly would have to do so very quickly. Again, looking at the sections of the Act, there is a requirement under Section, Section 6. It requires consultation by the minister with the community, and if both band council and municipal council operate in a community, there would be consultation with both. I've just been handed a bit of a list here of how things that might take place. Step 1, of course, a community decides it wishes to have a plebiscite, and the municipal council or band informally notifies the Department of Finance, let's say May 1st. Step 2, a legislative drafter is instructed to prepare a plebiscite order and implementing regulations, which are completed by May 30th. The omnibus territorial bill receives assent on Friday, June 1st, 2018. Step 4, a municipal council or band council meets and makes resolution requesting a plebiscite on Tuesday, June 5th. Step 5, a minister makes plebiscite order, fixed plebiscite day for Monday, June 25th, and appoints returning officer, and the plebiscite then would be held on June 25th. Step 7, assuming majority of voters approve the restriction, the minister makes regulations to implement the system on Wednesday, June 27th. So there isn't a lot of time left for communities to have plebiscites.
Mr. Minister, can you make that timeline you just read out available to this committee?
Sure. Yeah, yeah.
Mr. Minister?
Yes, we can certainly make it available to committee.
Thank you, Mr. Minister. And you mentioned that you as minister would be required to consult with the community upon the issuance of a license for a cannabis store. Can you just clarify if that's consultation or notice that must be provided? Mr. Minister?
It would be the Minister of Finance, but if I can refer to Section 6, before designating a vendor for the operation of a cannabis store and the sale of cannabis in a community that does not have an existing cannabis store, of course none do now, the minister shall, to ascertain the views of that community, give notice. Then if the community is a municipality, to municipal council. If the community is not a municipality, to any band council that operates in the community. If both a band council and municipal council operate in the community, to both band council and the municipal council. So it would be the Minister of Finance giving notice.
Thank you, Mr. Minister. So my understanding that giving notice is very different than community level consultations. Is that your understanding as well, Mr. Minister?
It would be less than community consultations, yes, I would say so.
Thank you, Mr. Minister. So it would really be up to the community after receiving notice to take the matter into their own initiative and pursue a plebiscite if they so desired. Is that an accurate assessment, Mr. Minister?
Yes.
Thank you. I'll move to Mr. O'Reilly. Time starts now.
Thanks, Mr. Chair. Yeah, I'd like to turn to Section 14 of the Act, which would seem to prohibit a plebiscite on restricting cannabis in a community once a cannabis store is in operation. This seems to be really tipped in favor of business, and I'm trying to find a more reasonable balance of interests here. You know, if a community does change its mind after a couple of years or more, there doesn't seem to be any way in which they could seek a plebiscite to place further restrictions on cannabis. And you mentioned that there doesn't seem to be a process, or that there was nothing similar in the Liquor Act around that. Well, I beg to differ. Section 57 of the Liquor Act does allow for a plebiscite to be held with regard to a licensed premises or class of premises. If 20% of the voters ask for one, the minister has the discretion to actually hold a plebiscite. So that would seem to serve as a model that would more appropriately balance the interests of communities and their citizens and business owners. So is this something that the department or the minister is prepared to look at as a model? Thanks, Mr. Chair.
Mr. Minister?
Thank you, Mr. Chair. Of course, we don't have any licensed premises for the consumption of marijuana, cannabis, and I understand that Section 14 is not dissimilar to sections in the Liquor Act dealing with stores that are selling liquor. Thank you.
Mr. O'Reilly?
Thanks, Mr. Chair. I don't think I got an answer. I'm not talking about, this is a model of an approach that more appropriately, in my view, seems to balance the interests of a community and its citizens and business. Right now, Section 14 is completely in favor of a business owner. There's no way that a community could seek a plebiscite once a cannabis store is open. So is there some other way that we can get a better balance of interests? And is the minister prepared to look at Section 57 in the Liquor Act as a model for allowing that? Thanks, Mr. Chair.
Mr. Minister?
Thank you, Mr. Chair. Well, generally speaking, dealing with liquor stores, they enter into fairly lengthy contracts, and although there's going to be initial shorter period of contracts with the cannabis stores, I think the owners of those stores are going to need some certainty going forward that their ability to sell will not be dependent on a change in the local opinion. After all, they may have to make significant investments in setting up a cannabis store. So, yes, this does restrict the ability of communities where there is a cannabis store to prohibit the cannabis store, but I think it's reasonable in view of the contracts that we're likely to be entering into with the cannabis vendors. Thank you.
Thanks, Mr. Chair. Well, I would hope that the minister is prepared to look at a better balance of rights and interests here, because right now it's tipped completely in favor of business owner, and maybe the government's worried they're going to get sued or something, but I just want to change tax a little bit on this now in terms of, say, a community like Yellowknife here, where we have a First Nation that lives partly within the boundaries of the city of Yellowknife. Would the community of Delo or the community of Dead, could they be in a position where they could request restrictions or prohibitions on cannabis within their communities? Thanks, Mr. Chair. And the reason I ask that is because the definition of community in here is rather vague, to say the least. I'd say it includes municipal councils and First Nations councils, bank councils, but it doesn't have anything to say really with regard to overlapping boundaries or jurisdictions and so on. So can the minister shed any light on this? Thanks, Mr. Chair.
Mr. Minister?
That is an interesting question, and as I understand the question, if an Aboriginal community is within the municipal bounds of a larger community, I don't know whether they could ban, I don't believe they could ban a liquor store or prohibit a liquor store beyond the bounds of their community, but surely the establishment of a cannabis store within their community, they would have a decision or the right to make a decision on that because it's their community. I don't think, however, they could ban or prohibit or restrict beyond the bounds of their own community. That wouldn't seem to be likely.
Thank you, Mr. Minister. Mr. Riley, your time has expired. Mr. Simpson, you have the floor.
Thank you, Mr. Chair. Section 2 of the Cannabis Smoking Control Act states that cannabis cannot be smoked in a public place, and the Act gives the minister and municipalities the authority to further restrict where cannabis can be smoked through regulations or bylaws, respectively. The definition of public place includes any facility, whether covered by a roof or not, that the public has a right of access to. Could you provide some clarity on what is meant by a public place, perhaps by providing some examples? Thank you, Mr. Chair.
Mr. Minister?
Thank you. Where's that list? Okay, well, here is the list where smoking cannabis will be prohibited under the Act. And it includes all or any part of a building, structure, or facility, whether covered by a roof or not, to which the public has access as of right or by express or implied invitation, including the buildings and grounds of a school, as defined in the Education Act, a facility as defined in the Hospital Insurance and Health and Social Services Administration Act, an outdoor bus shelter, a building, structure, or facility, or any part of a building, structure or facility that is used for private events, a building, structure, or facility that is owned or leased by a private club that restrict admission to members, and a building, structure, facility, or place that is prescribed specifically or by class. So we've kind of taken the view that it's going to be like the prohibition on smoking plus additional, it's, those definitions are contained in the Cannabis Smoking Control Act under the definition of public place. Thank you.
Mr. Simpson.
Thank you, Mr. Chair, and yes, that's what I'm referencing, what a public place is. And that's a pretty legalistic explanation. I said it's a facility with a roof or without a roof that the public has access to. Now, is that a skate park? I mean, is that a park? Is there the gazebo in the park? Is it middle of the street? People are asking me, where this is going to be allowed, and I'm trying to get an answer for them in plain language. Could you give us a plain language answer of what a public place is? Thank you, Mr. Chair.
Mr. Minister.
Well, as I don't want to repeat the definition, I mean, clearly there are areas that that we are not going to allow cannabis smoking in buildings and grounds of a school. I don't know whether I can add anything to this this rather extensive definition in the Cannabis Smoking Control Act, but as I say, it is somewhat similar to the prohibitions respecting tobacco, but is certainly broader. Thank you, Mr. Chair.
Mr. Simpson.
Thank you, and maybe the department can provide us with a little more clarity with a written piece later, so I can provide that to my constituents, because I don't want to just direct them to the definitions of the Cannabis Smoking Control Act. So I guess this next question is probably the same answer. The regulation gives the minister power to create, the act gives the minister power to create regulations that ban smoking cannabis in other prescribed areas. It also gives the minister power to exempt certain areas from this prohibition. Are there any places that the minister expects to designate as additional places where there are restrictions on smoking or exemptions from this act? Thank you, Mr. Chair.
Mr. Minister.
Yeah, some additional restrictions are likely through regulation, outdoor playgrounds intended for children's use and 30 meters from the boundary of a playground, outdoor bicycles and skate parks intended for youth's use, and 30 meters around that, outdoor sporting fields and 30 meters around that, and public parks within a municipality when in use for public events and 30 meters around the boundary of the park. So, yes, there will be regulations that will expand on the definition of public place.
Thank you, Mr. Minister. Mr. Simpson, your time has expired. I can put you back on the list. We'll now move to Ms. Green.
Thank you, Mr. Chair. Mr. Chair, I'd like to talk to the minister about youth and cannabis use. The federal government set a minimum age for youth to smoke cannabis, but the territorial government had the discretion to put the level at a higher age. Considering the importance of brain development in youth up to the age of 25, I'm wondering why the minister chose 19. Thank you.
Mr. Minister.
Thank you, Mr. Chair. Yes, we obviously looked at what other jurisdictions were doing. Some of them are 18, I believe, Alberta and Quebec, and the rest are 19, and we went with this age of 19. Yes, we do understand that there is some evidence that the use of cannabis may be harmful to young people up to the age of 25, but I don't think it was practical to have a prohibition up to that age in view of what our understanding is of current usage. Thank you.
Ms. Green.
Thank you, Mr. Chair. Could the minister please define not practical? Thank you.
Mr. Minister.
Well, I suppose you could have what we've had for the last 90 or 100 years, which is a prohibition. Clearly, that isn't working. Our understanding is that a considerable number of people in the 19 to 25 age group are consumers already, as consumers of cannabis already, and we didn't want to criminalize any more that activity. Thank you.
Ms. Green.
Thank you, Mr. Chair. Mr. Chair, the federal legislation provides for a limit of youth possession of up to 5 grams. And after 5 grams, the youth are subject to the potential of criminal code offenses and of course, a criminal record, depending on their age. But less than 5 grams, there's a simple seizure and or notification of parents. Now, this government has gone a step further and decided to provide fines for youth who are in possession of less than 5 grams. What's the rationale for that? Thank you.
Mr. Minister.
Yes, there's quite a difference, though, in the punishment, if I can put it that way, that we're imposing. This will not give those young people that are charged with possession of criminal record, and there's also a limit on the amount of the fine. We did not give a floor or a ceiling, whichever it is, to the amount that they might consume, as the federal government has. But I think the federal government, as I mentioned earlier, one of their main concerns was to avoid people in general and youth specifically from getting criminal records. So that's why I think they had this 5 gram amount. Thank you.
Ms. Green.
Thank you, Mr. Chair. My question is more about why the territorial government has gone to the additional step of not just seizing the cannabis and telling the parents, but deciding to levy a penalty on youth who have possession of less than 5 grams. Thank you.
Minister.
Yes, I would hope that some discretion and common sense would be used in the laying of charges in this area. But as I said, the penalty, we did want to have a clear message sent out that we are concerned about the consumption of marijuana by youth, and therefore it was felt, remembering that these do not result in criminal convictions or record, that we would not have a limit that was allowable, as it were. Thank you.
Thank you, Mr. Minister. Ms. Green.
Thank you. So when it comes to youth possessing tobacco and alcohol, can you tell me if they are subject to the same regime of fines for possession? Thank you.
Mr. Minister.
Yes, I understand that that is the case. Thank you.
Ms. Green.
Thank you. I have a question about edibles. Many people these days choose not to smoke cannabis or any other products and would prefer to consume cannabis in the form of edibles. Can the minister tell us when he foresees making edibles legal in the same way that the smoking product will be? Thank you.
Mr. Minister.
Well, of course, we're waiting for the federal legislation, and I don't think they're contemplating edibles in the first round of legislation. My understanding is that they are contemplating edibles to be decriminalized, if I can put it that way, in 2019. So we have to wait to see what happens with that legislation. Thank you.
Thank you, Mr. Minister. Ms. Green, your time's expired. Mr. McNeely.
Thank you, Mr. Chair. My 2 questions at this point in time would be around the issue of public safety and awareness. My first question is there an impairment level to determine the individual's impairment? And if there is a level, what supporting research has been done to justify this level? Thank you, Mr. Chair.
Thank you, Mr. McNeely. Mr. Minister.
Yes, thank you. As the federal legislation works its way through Parliament, I understand it initially, and perhaps is still the case, is they had different levels of impairment, the fines going up with the level of impairment, the penalties going up with impairment, but perhaps I could best refer that to workers' compensation for an answer, Mr. Chair.
Thank you, Ms. Keynes.
So with impairment with regards to workplace safety, it comes back to fit to work and being able to do your job safely. And that's something that employers are currently dealing with, and they deal with through policies. And that's what they'll continue to do. We are developing education tools for them to help them. The level of them, it's not like driving where you can set a particular level, because it depends on what sort of activities they're doing at work. So looking at the fit to work legislation and impairment to make sure that you're fit to do your job safely, whatever your job is. So it's not as easy as putting a level to it. So, but we are looking at developing tools and help for employers and workers to address that.
Thank you, Ms. Keynes. Mr. Minister, the section of Bill 6 that deals with the amendments to the Motor Vehicles Act, does that speak to impairment at all? I just want to make sure that we cover all areas where impairment applies, especially in the legislation before us. Mr. Minister, when you're ready.
Through the legislation here, I think, pardon? Yeah. Perhaps Megan could speak to this.
Yes, thank you.
Ms. Birch.
So your question about the impairment under the Motor Vehicles Act amendments. So with those Motor Vehicles Act amendments, we're looking at zero tolerance for certain groups of drivers. So you don't have to prove impairment there. You just have to prove there's any level of cannabis or another prohibited drug. But we're also looking at new suspensions for failing a standardized field sobriety test or failing an evaluation by a drug recognition expert, which are tests and evaluations used to detect drug-impaired drivers and alcohol-impaired drivers as well. So we don't have any levels like they do under Bill C-46, which is the federal bill that's going to replace the transportation section of the criminal code with, they're going to introduce, for example, 3 new offenses for having a certain level of THC in your system while driving. We don't speak to specific levels for our Motor Vehicles Act amendments, but we do speak to impairment tests.
Thank you. Mr. McNeely?
Okay, thank you for the clarification and reply. It still doesn't satisfy me in telling the people that I'm going to represent, here is the level to determine you're impaired from this substance. As with alcohol, we can tell them anything over and above 0.08, you are not allowed to operate a vehicle and you're impaired. But I haven't heard the reply on a number that would determine you're impaired by this cannabis substance. But yet I heard that you're going to charge or enforce offenses on the quantity of the substance. And we have 71 days to prepare for some of these systems that we're going to have our enforcement personnel to act on. Now, he or she or the bylaw officer might say, well, I don't know what the impairment level is. I've got a breathalyzer, a piece of equipment here, but it's not programmed to determine at what level. So I bring that out as a notice that we got 71 days to get some answers on what the impairment level is. And so that's my notice brought forward to that. And my next question is on-site safety. Is there a MOU on collaboration with the WSCC organization to educate the employers that they represent for on-site safety and some of the questions that I'm sure that they will have and need answers to through a Q&A booklet that could be publicized and sent out, or community on-site visits with the employers. Is there a collaboration, move forward, advance agreement between our government and WSCC? Thank you, Mr. Chair.
Mr. Minister?
Yes, I understand that as far as workers' compensation, there's zero tolerance of impairment, whether it's by liquor or drug, but perhaps I can let Ms. Keynes expand on that.
Ms. Keynes, may proceed.
Thank you, Mr. Chair. We do our mandate is under the Safety Act and the Workers' Compensation Act is collaboration, education, and enforcement of those acts. And part of what we do with our mission, vision, and values is working with employers and workers to educate them on compliancy with the legislation. So, and that's always the first tool brought forward is collaboration and education. So, and that is what we'll be doing with this new impairment, is looking at, you know, how do we help our employers? How do we educate them? How do we educate our workforce in order for them to come to work safely? Because our goal is that they come to work and they go home safe. So, thank you.
Thank you. Mr. McGinley, your time's expired. We'll now move to Mr. O'Reilly.
Thanks, Mr. Chair. So I'd like to know what sort of work we've done to get better prepared in terms of educating the public about the advantages and disadvantages of cannabis use. Thanks, Mr. Chair.
Mr. Minister.
I know that the federal government is preparing information that will inform the population as to the risks surrounding cannabis, and I believe our health department is additionally preparing information to be sent out to the public. Perhaps I could have, perhaps Gary could answer this.
Mr. Toft.
Thank you, Mr. Chair. I can give you a brief overview of the first phase of the campaign, what we are working on right now, and do that quickly. Beginning next week, some members may have seen a booklet that's put together by the federal government. A number of people had suggested, including I think the member for Yellowknife Centre, that this be distributed throughout the territory. So we've got 13,000 copies of this going out to households next week. We're creating a website which will be cannabisnwt.ca, which will be up and running soon. I've talked about some of the direct mail. We're also going to be doing some newspaper ads, some social media, including paid advertisement. We'll be working on a video series similar to some of the other public education work that we've been doing. We'll have an information brochure that our environmental health officers will be able to share with people, informing them the rules around where you can and cannot smoke cannabis. We'll be providing some information to educators and to schools, including banners and a teacher resource kit. We'll be putting together a series of ads to run on radio in 9 Indigenous languages. We'll also be involved in other activities such as identifying community champions and working with them to spread information in some of the smaller communities that the people can use to be aware of the risks and the harms, and be informed about so they can make decisions for themselves.
Mr. O'Reilly.
Thanks, Mr. Chair. So that's all sounds very good and interesting. How much is this campaign costing us? Thanks, Mr. Chair.
Mr. Toft.
Yes, the first phase of the campaign, our budget will be approximately $125,000.
Mr. O'Reilly?
Thanks, Mr. Chair. I'm just wondering if anybody, I had a member of the public draw this to my attention, that New Brunswick has a bill before its legislature, Bill 18, Cannabis Education and Awareness Fund Act. And I guess they've arranged with their suppliers that they are going to provide 2% of their gross sales to the province to support efforts on education and awareness and some research, and that this would go into a special fund. There'd be an advisory board for it. Sounds like a really interesting idea. I know governments and finance people really hate targeted revenues, but is this something that our government is looking at to help finance our education programs that are going to be necessary as a result of legalization? Thanks, Mr. Chair.
Mr. Minister, are you prepared to speak to that?
Yes, no, we're not contemplating that at present, and we imagine we'll simply go through the business planning process. Thank you.
Mr. O'Reilly?
Thanks, Mr. Chair. So if we don't set up an arrangement like this where we actually target some of the revenues, where do the revenues come from, and how much is this going to cost us over a period of time? We haven't seen any cost estimates government-wide from you folks at all, or revenue estimates. So where are we going to get, where and when are we going to get this kind of information? Thanks, Mr. Chair.
Mr. Minister?
Well, it's revenue forecasts are a little difficult in this area since the product is illegal. The sale of it's illegal. And we aren't contemplating a designated amount, the 2% that New Brunswick is contemplating, and I don't think we do that with liquor revenues either, so it'll just be part of general revenues, I assume. Thank you, Mr. Chair.
Thank you, Mr. Minister. Mr. O'Reilly, your time's expired. I have a question around the possession limit. So the legislation is consistent with the Federal Cannabis Act in allowing possession of up to 30 grams of dried cannabis and 4 plants. However, it's unclear whether or not that's an absolute limit on possession or whether or not it's personal possession. Mr. Minister, can you speak to that issue?
Yes, there is some confusion around this issue, which we acknowledge, and we are planning to introduce a motion that makes it clear that 30-gram limit is not intended to prohibit a person having more than 30 grams in their dwelling house. Several provinces, or at least one, is a top limit of 150 grams. I don't think we're contemplating that, but we do acknowledge that the legislation needs to be clarified. Thank you.
Thank you, Mr. Minister. So what absolute limit is the department prepared to set, or is that still to be determined? Mr. Minister?
I don't think we're looking at setting an absolute limit. I suppose if it was an incredibly high amount that was possessed, it might draw the attention of the authorities because it might be such an amount that it might indicate a trafficking situation. But as I say, Quebec apparently has thought that 150 grams is reasonable for in-house possession, if I can put it that way, other than public anyway.
Mr. Minister, can you just then clarify for members of the public who might not be as technically savvy with the contents of legislation, but how, once legalization day happens, how much, well, I'll split into 2 questions. The first being, how much can an individual purchase from a cannabis store at one time? Mr. Minister?
Yeah. It would seem to me that it would be 30 grams because that's the amount we're going to be allowed to be possessed in public. If you're purchasing it from the store, I assume the vendor should not be selling you more than 30 grams because the store and the area around the store would be a public place. Thank you.
Thank you, Mr. Minister. And how much can an individual keep at home beyond the 4 plant? How much? Sorry, there's the 4 plant limit, which is well established. how much dried cannabis can an individual keep at home? Mr. Minister.
Again, we're not contemplating putting a cap on that. Thank you.
Thank you, Mr. Minister. So the bill also makes mention, or it has several components related to areas of legislation that the department has, or that you have indicated are for future considerations but aren't going to roll out right away. One of those is the ability for retail outlets to sell cannabis products that are not in the government liquor control system. Another one is special purpose occasions or special occasion permits. So you could have a permit to consume cannabis in a public area, and cannabis advisory committee. So I just would like some clarification. Why are these issues in the bill if there's no plans to use them in any time in the future? Mr. Minister?
Well, we wanted to have the ability, ultimately, if we decide to expand the cannabis distribution system beyond the liquor stores, have the ability to do that in the future. Now, we're not planning on doing that off the bat, if I can put it that way, because we're planning on using the current liquor vendors, and again, it's up to them whether they decide to do this as the distributors for cannabis. Thank you.
Thank you, Mr. Minister. And obviously, just again, for the purposes of our audience, this bill does not speak to production. Can you just clarify whose responsibility regulating production is, and how, and whether or not, or how an NWT, an interested party in the NWT, could involve themselves in the production side of cannabis? Mr. Minister.
Thank you, Mr. Chair. That's quite correct. This bill does not address production, which is a federal concern, so it would be necessary to become licensed through the federal government. I don't know whether any organizations here are planning, or individuals are planning to make application, but that has to be made to the federal government. As I understand it, there's none approved at this point. Thank you.
Thank you, Mr. Minister. Mr. Simpson, you have the floor.
Thank you, and I'd like to follow up with my colleague regarding the special occasion permits, and I was unaware that the department had no plan to use this, because the authority to grant them is in Section 24 of the Cannabis Products Act. It allows the possession, it authorizes, a permit would authorize the possession, transportation, consumption, and use of cannabis at a function. And so I'd like to know if the department does plan on using this, because I imagine a year from today, there's going to be quite a few special occasion permits, applications for them. So does the minister intend to explain in regulations what will be needed for one of these permits? Thank you, Mr. Chair.
Mr. Minister.
Well, I imagine it would be somewhat similar to the special occasion licenses that can be granted with respect to liquor. So the application would have to be made and could be accepted. I don't think I'd be the minister. Yes, it would be to the Minister of Finance in any case. But yes, the provision is there, and I imagine it would be similar, as I said, to the special occasion permits with liquor.
Mr. Simpson.
Thank you. So when this act becomes law, the regulations will roll out soon after, allowing for special occasion permits. Is that correct? Thank you, Mr. Chair.
Mr. Minister.
Yeah. Well, of course, the act does contemplate special occasion permits. As to the format of the request, perhaps I could turn to finance.
Oh, sorry, Mr. Kalgotkar.
Thank you, Mr. Chair. So as the Minister has indicated, the Cannabis Products Act essentially mirrors the Liquor Act and the guidelines and rules that govern the issuance of special occasion permits will likely, for this act, will likely mirror the same as the Liquor Act. Thank you, Mr. Chair.
Mr. Simpson.
Thank you. So I guess, will those mirrored regulations be rolled out, when, I guess? When is the timeline for rolling out the regulations? Because for those who don't know, when we approve an act or when we look at a bill, it's the elected members of the public get to look at the act. And those acts give wide discretion to the departments and the ministers to develop regulations, which really hash out the acts, no pun intended. And so when can we, and this, this is a big bill, there's lots of regulations that could be created, so what is the timeline for creating regulations? And I know that some will be prioritized over others. Thank you, Mr. Chair.
Mr. Minister?
It's difficult to give a timeline, Mr. Chair, but clearly this have to be done. I hate to give the response as soon as possible, but it obviously would have to be done because the form or format of the application for a special occasion permit would likely be set out in the regulations. So, thank you.
Mr. Simpson?
Thank you, and I assume that under the Liquor Act, these permits go through the Liquor Board. Is there a similar setup envisioned for cannabis? Thank you, Mr. Chair.
Mr. Minister?
Perhaps I could turn that over to Finance.
Mr. Kalgutkar?
Thank you, Mr. Chair. Our current thinking behind the special occasion permits is we don't really foresee that they're going to be issued immediately. So we don't believe that we're going to be setting up that they will be going through the Liquor Board for consideration. The purpose of them in the Act now is so we could consider it at a future date, but there is no contemplation that we'll be issuing any special occasion permits anytime soon. Thank you, Mr. Chair.
Mr. Simpson?
Thank you. And just for clarification, will the Liquor Board be handling any cannabis-related business? Thank you, Mr. Chair.
Mr. Minister?
Well, yes and no. I mean, they will be dealing with producers of cannabis, but perhaps I'll turn it again over to Finance, whose department this is.
Mr. Kalgutkar?
Thank you, Mr. Chair. So my understanding is that they will not be involved in handling cannabis products at this stage. Thank you, Mr. Chair.
Mr. Simpson?
Nothing further on this subject. Thank you, Mr. Chair.
Thank you, Mr. Simpson. Mr. Thompson?
Thank you. I'd just like to go back to the plebiscite and the timetable that you've given us for communities that have liquor stores in it. You gave May 1st as the date to start the process. We're not even going to be finish our consultation until May 4th. So can the Minister explain what the government is going to be able to do to the communities that have liquor stores to help them be prepared to provide get the much information as they need to provide a plebiscite? Thank you, Mr. Chair.
Mr. Minister?
Well, I understand the departments have been in touch with various municipalities, and I know this is a concern of municipalities, and I can't remember whether it was addressed at the latest NWTAC meeting, but I know it is a concern. As I mentioned, there is a requirement under Section 6 that there be a notice given to the communities. So. And as I mentioned earlier, that we would be doing that as soon as possible. Thank you.
Thank you. And just if everyone could check that their phones are in the silent position, picking up some feedback on our audio system. Thank you very much. Ms. Thompson?
Thank you, Mr. Chair. I guess my concern is how are we going to get these communities prepared? Like, the thing is that with regulations happening as of July 1st, and as we're moving things forward, right now we're having this challenge. So what is the government going to be able to do to help these communities, these 6 communities, be prepared? Like, I mean, yeah, talking to them, but if they don't do it, then guess what? There's not going to have that opportunity to do a plebiscite. So what is the government being able to do to address this concern? Thank you, Mr. Chair.
Mr. Minister?
Well, to some degree, we're driven by forces beyond our control. The federal government is going to be getting its legislation completed. I think the latest date is expected to be mid-August, so that's the date that they're looking at. We want to be prepared for that date as best we can. So, as I say, this is an issue I know that our officials have gone around to various communities, and your committees are going to 10 or 20 communities in the near future, so it'll be interesting to see what they say. I believe that most of the communities in which there is a liquor store do understand that those stores are very likely to be selling cannabis in the near future. I think that the department has been in touch with the owners of those stores, so this is not terra incognita, if I could put it that way, because this issue has certainly been before the public for some time. Thank you.
Mr. Thompson.
Okay, thank you, Mr. Speaker. It's great that you're getting hold of liquor store people, but we're talking about municipal governments and band councils in these communities and Métis locals. So you're giving them that opportunity. So, but if you're not talking to them, how are you getting them prepared? Like, it's great to say, well, you know it's coming. Well, I know Christmas is coming too, but you know, it's going to be December 25th. At least I'm going to start planning for it. I mean, how are we helping the communities prepared for a plebiscite? Because these communities have been asking me that question, and I have no answer to it because I don't know what the government's doing, what the government has done to prepare these communities. So can you tell us what they're going to be doing, and if you haven't, could the community come up with a plan? And is there some flexibility to change the schedule so that, you know, there's some little bit of leeway for the communities to decide? Thank you, Mr. Chair.
Mr. Thompson, Mr. Minister, to the question of plebiscite preparation. Mr. Minister.
Yes. I know that we have been in touch with the communities, but perhaps I can let Finance respond to that, Mr. Kulkar.
Mr. Kalgatkar.
Thank you, Mr. Chair. So, as the Minister indicated to committee earlier about the several steps that need to be undertaken as part of the plebiscite process, one of the first steps that we will be doing is working with the Department of Municipal and Community Affairs and start informally helping communities develop some of the requirements of the plebiscite so that they are prepared. So we will, the Department of Finance and MACA will start that process fairly soon. Thank you, Mr. Chair.
Mr. Thompson.
That's great, and that's very positive to hear. Will we meet the deadline? Will we be able to allow those communities, i.e. the 6 communities that have the liquor stores in there, which are going to be providers of cannabis, are we going to be able to give them enough time to be able to make a decision if they're going to have that plebiscite? Thank you, Mr. Chair.
Mr. Thompson. Mr. Minister.
Well, as I mentioned previously, the federal cannabis legislation is rolling ahead. We are in touch with these communities and certainly can inform them of what they need to do should they require or should they request a plebiscite on this issue. So we'll do our best. Thank you.
Thank you, Mr. Minister. Committee, we have time for 2 more rounds of questions. Ms. Green, you have the floor.
Thank you. My questions relate to the Motor Vehicle Act amendments, and they're specific to impairment for operating a vehicle. So impairment is established for driving a car, but impairment is not established for ATV drivers, and yet ATV drivers can be as young as 14. And so my question is related to this area. Is the territorial government going to address the area of impaired driving of ATVs for youth? Thank you.
Mr. Minister.
To some degree, that's addressed already through the criminal code because motorized vehicles include ATVs, snowmobiles, motorcycles, and so on. I might refer this to the department. Pardon? Infrastructure, Department of Infrastructure. Thank you.
Ms. Birch?
Thank you. So, as there's no driver's license required to operate an all-terrain vehicle, the appropriate recourse to deal with impaired driving would be under the criminal code. So given that there are no driver's licenses required for those, we can't look at things like administrative license suspensions territorially. And it is the criminal code that you have to deal with the impaired driving aspect of that.
Ms. Green?
I just want to make sure I understand this. So if there's a 15-year-old who is found to be impaired while operating an ATV, that person can be charged under the criminal code with impaired driving, is that correct?
That's correct. They would go to youth court, but yes, they would be charged.
Sorry, we'll have to, Mr. Minister. Go ahead, just repeat yourself.
Yes, that person would go to youth court, but it is a criminal offense.
Thank you. And Ms. Green?
Okay, so what I find odd about this is we just had a conversation in my last set of questions about not making, sorry, I'm just getting my thoughts in order here. The conversation we just had was about giving youth a chance not to acquire a criminal record for possession, but they are going to acquire a criminal record for impaired driving. So why is that distinction necessary? Why isn't there another way of dealing with that? Thank you.
Mr. Minister?
Because impaired driving, Mr. Chair, is such a serious matter in our society, and whether you're 15 or 25 or 55, it's a criminal offense. And therefore, anybody who is over 12 can be charged and face criminal consequences, which I think is appropriate. Thank you.
Ms. Green?
Thank you. And can you please confirm that the criminal code charges for impaired driving apply for vehicles that are operated off the road surfaces? Thank you.
Mr. Minister?
I don't have a copy of the criminal code in front of me, and I can't remember what it says in a public place or not. Certainly you don't have to be on a regular roadway. You can be in a place where the public has access to, and people certainly are charged for impaired driving in those circumstances. If you're driving your lawnmower impaired, you may not be chargeable on your own lawn. But
Well, Ms. Green, go ahead.
Okay, if I understand the minister's answer, it is possible to operate a riding mower while impaired?
Mr. Minister, clarification?
not advisable, but it all depends where it's being driven. I mean, if you're driving in a little compound in your house, it may be different than driving in a place where the public has access. Again, I haven't looked at that section of the criminal code lately, but that's a federal matter. Thank you.
Mr. McNeely?
Thank you, Mr. Chair. My first question is in enforcement staff training. Has there been any training plans there put in place here for enforcement staff, whether it's the bylaw officer, the RCMP, the training necessary in preparation for what's going to become law in 71 days? Thank you, Mr. Chair.
Mr. Minister?
Yes, perhaps Mr. Toft could answer that question.
Thank you, Mr. Chair.
Oh, sorry, Mr. Toft.
Thank you, Mr. Chair. Yes, the Department of Health and Social Services, our environmental health officers are in discussions with the Department of Justice to identify the appropriate training that they will need and to put together a work plan to make sure that our environmental health officers do get the training required.
Mr. McNeely?
Yes, thank you for that reply. You had mentioned environmental officers. I'm talking about the enforcement officers, say the RCMP downtown Fort Good Hope, for example. If he or she's going to have the law to enforce this, are they getting the necessary training to execute the penalty in relation to cannabis consumption? Thank you, Mr. Chair.
Mr. Toft?
Thank you, Mr. Chair. The enforcement of the prohibition of public smoking in designated spaces, the primary responsibility will fall to environmental health officers at the Department of Health and Social Services. So we are, as I say, working with the Department of Justice to make sure that they have that training in place and they are prepared to enforce. We did have, if I may, we did have conversations with the RCMP about whether or not they would want to be involved in the enforcement of public smoking. Their message to us is that they saw this as a public health matter as opposed to a public safety or a security matter. That said, that they did volunteer that if environmental health officers got themselves into a position where they reached the limits of their authority and a situation became more of a something that would be dealt with under the Criminal Code of Canada, the RCMP would come in to assist.
Mr. McNeely?
Yeah, I find that kind of troubling here when everybody in the smaller communities and internationally, nationally, is under the impression the RCMP and bylaw officers are there to enforce the law. Now we seem to be giving the impression that, okay, we're going to pass the responsibility on to the health officer. So in some communities, we do not have a health officer, let alone a RCMP officer. In some communities, it's the other way around. We have an RCMP officer, but we got no health officer. And wouldn't that jeopardize the enforcement of the consumption of cannabis? Thank you, Mr. Chair.
Mr. Top? Oh, sorry, Mr. Minister, this is more appropriate. Oh, Mr. Top, okay.
Thank you, Mr. Chair, and thank you for the thoughtful question. We've spoken to communities about this on two or three occasions. Under the proposed legislation, as you will see, municipalities, communities also have the authority to create their own bylaws. And my understanding, there are some that are considering doing that at this point. And just as there are bylaws in effect currently to expand the prohibition on the smoking of tobacco, and municipalities will have the authority to enforce their bylaws. They will also be able to request to the territorial government that they be allowed to enforce the territorial legislation as well.
Mr. McNeely?
Okay, I'm somewhat satisfied with that at this point in time here, considering time, and I don't agree with this time factor. You know, we have a lot of work to do, but yet only 71 days to do it. And already, you know, in the spirit of democracy, we're looking at the clock right now saying, you know, we're restricted on time. We want to get educated how this is going to be delivered, how Bill 6 is going to be delivered and carried out and implemented. And right now, there's very little awareness out there. For an example, you know, we can come back and say, okay, we sent a package here in January to the local governments. That's just reading material. You're better off to educate the communities by going there. And our consultation for the next 2 weeks is going to exclude some communities. Is that education or not? It's not. So I'm being mindful of that. And on the spirit of education, I go back to WSCC. The employer community is being charged a premium of $2 to $5 per $100 of payroll. In exchange for that for that premium, they get some services, safety training, safety courses, safety presentations, and so on. So there's a return on that premium cost to the average business. Now, that's one method of educating the business community. So when we, as a government, go out and educate the other people, we can say, okay, well, there's a cooperation agreement between the Department of Justice and WSCC to look after that community or that clientele. And using the resources of the premiums paid on payroll could deliver that education. Now, if we can focus on responsibilities and delegation, then we can focus on the general public to make sure their answers are provided to their questions. There's a lot of questions out there. So I just bring that forward to recommend to the department establish this collaboration MOU with the WSCC in delivering to that community they represent on awareness and education of Bill 6. Thank you.
Okay, thank you, Mr. McNeely. Your time's expired, but Minister, I'll allow you to respond to the question around an MOU with the WSCC. Mr. Minister.
Yes, we realize that education is an important component of this, and I know that WSCC has been working with employers. I don't know whether really I have anything to add. You've heard how the federal government is assisting with education, as are we, but we understand the concerns of the communities. Thank you.
Thank you, Mr. Minister, and this concludes the public portion of this meeting. I'd like to thank the Honourable Louis Sebert and all the witnesses for providing their evidence today. You may be excused. Or did you have something to close with, Minister?
Yes, first of all, I'd like to thank everybody for their input today. This is an omnibus bill which covers a lot of areas. I hope we've been able to answer some of your many questions. We are driven by the fact that the federal legislation, of course, which was announced about a year ago, hasn't given us a lot of time, but I think there are very good reasons why the federal legislation needs to go ahead. We want to take this product out of the hands of the underworld and regulate it as best we can. There are, I know, a great number of concerns, many of which have been raised today. I was asked by Ms. Green a question. I will read the relevant section of the Act, Criminal Code. Everyone commits an offense who operates a motor vehicle or vessel or operates or assists in the operation of an aircraft or a railway equipment or has the care and control of a motor vehicle, vessel, aircraft, or railway equipment, whether or not it is in motion or not, while a person's ability to operate the vehicle, vessel, aircraft, or railway equipment is impaired by alcohol or drug, or having consumed alcohol in such a quantity that the concentration in the person's blood exceeds 80 milligrams of alcohol, 100 milliliters of blood. So that's what the legislation says. I may have been thinking of earlier. It doesn't say where, and I thought that was one of the defenses we used to raise. I don't know if we, in my former profession, that would work anymore. I'd have to look at the cases surrounding it. But I think the important thing is that it would apply to everybody, no matter what their age is, well, above 12, or 12 and older, 12 to 17. So thank you, and thanks again to committee. You've certainly given us many things to think about. I wish you well on your travels. You're going to be hearing from the communities, and hopefully, and I'm sure we'll come back with suggestions for us. So thanks again.
Thank you, Mr. Minister, and thank you again for your evidence. You may be excused. I'll ask for a motion to go in camera. Mr. Nadley, all those in favor? Thank you. Committee, we're now in camera, so I'll ask members of the public to excuse themselves from our committee room as well. Thank you.